Hi, I'm Rosy Sullivan. I'm the Principal of the Australian College of Professionals, and I just wanted to have a really quick chat with you about the latest updates to the reforms for the property industry. It's been going now for about 18 months, so we've got some updates. The draft bill is ready to go to Parliament probably next month, and some of the issues that we originally talked about have changed a little bit. Some have been refined. So Fair Trading have been really good. They've taken on board lots of suggestions. So I just wanted to go through where we were with that, because last November, Victor Dominello, the member, he was the then Minister for Innovation and Better Regulation, he released a reform paper for the real estate and property services industry. Now, most of you are aware of this. We've been talking about it constantly since it came out in November last year. They're generally divided, the reforms, into 5 separate categories. There's licensing and qualifications, obviously something that we're very interested in, continuing professional development, conduct and accountability, audit processes, and disciplinary powers. So now our current Minister for Innovation and Better Regulation, the Honourable Matt Keane, has continued to support the development of the property industry reforms, and he's working really closely with the reform team within New South Wales Fair Trading and with all the industry bodies to ensure that this initiative is actually brought to fruition, which is a great thing. We're working with the Estate Agents Cooperative, EAC, in terms of making sure that industry feedback is actually getting back to that reform committee. So since that initial release, there's been a lot of action taking place around all of this. So as I said, the draft bill, ready to go, and yeah, we're quite excited about that. It's progressing quite well. Okay, so we've done a written update of this, which you can find on the click on our website. So if you're watching this video, click beneath it if you want the written paper for just a quick 3-page summary and how it's actually going to affect your daily work practices. But if you're not into reading, then I'm going to go through what's actually in that paper now. So the initial reform paper is 43 pages long, the draft bill's 13 pages long. Our 3 pages is very much a shortened version with some of my personal comments attached to that. So we should be reminded that if the bill, if passed by both Houses of Parliament, will result in revisions to the Property Stock and Business Agents Act, and then Fair Trading, once it's through Parliament, will then undertake the process of developing the regulations that will work in conjunction with the revisions. Obviously, the regulations give us exactly what it means in your daily work. So once we receive more detailed information about the progress of that draft bill, we'll let you know. We'll let everybody on our database know about those changes. So as I said, we've been working very closely with EAC in the liaison with Fair Trading and having input into that property industry reforms, as EAC has participation in the reform committee. So as I said, the college is very much at the centre of knowing what's going on here. So let's have a look at those 5 specific areas. The first one being licensing and qualifications. So we've got the certificate of registration training will include more units of competency. Fantastic, it needed it. This will mean a longer course, a more detailed assessment, and probably from a reality point of view, a possible increase in price and incorporate those additional training requirements. A certificate of registration holder will need to obtain a license within 4 years. So they'll have that license and then, have that certificate and then need to move on to a license. The role of a person holding a certificate of registration will be defined, and some people currently holding certificates will no longer have this requirement. The definition there is more about what a certificate holder can't do, and that will be they won't be able to legally bind parties to a sales or management agreement or undertake trust transactions. Now that undertaking trust transactions is about the paying out from the trust account, not the taking in. So but that will be more refined and defined into the regulations. Now, the role of the licensee in charge will be more defined in terms of their supervision responsibilities. So we'll get new supervision guidelines. Great. Let's move on to licensing. To obtain a license, an applicant must hold the required certificate for in property services qualifications. So that's no change to what we currently have. But they will also have to have 12 months of practical experience in the industry. So that's practical experience for a real estate licence from a sales and property management perspective. In strata, it'll be experience at strata. In stock and station, it'll be experience in livestock and rural land. So that's a new one. It's kind of back to the future. It's back to where we were pre-2003. So again, we believe that's a really good thing. So then there'll be a new license category will be created. For now, we'll call it a licensee in charge license. They're looking at calling it something else, but that's where it'll be. It'll be the licensee in charge category. So it's a new category, and applicants for that category will need to hold a diploma level qualification from the property training package or the Certificate 4 in Property Services plus a Certificate 4 in a Business Management qualification. So in addition, a person making an application for that licensee in charge license, they must also have at least 2 years of experience within a licensed business. So they would need to prove to Fair Trading that experience as part of their application, that they've achieved specific competency during those 2 years of practical experience. And again, it'll focus on the specific areas that that person is working on. So that's an interesting change there. The supervision guidelines for the new licensee in charge category of license will reflect those requirements. Of interest to a lot of people is that the buyer's agent's license, the on-site residential property manager's license, and the business agent's license will be incorporated under the one real estate license categories. And for those of you who sometimes perhaps forget to renew your licenses, the renewal periods can be chosen from either a 1-year renewal or a 5-year renewal. So probably a cost saving they're suggesting, but certainly a time saver. So a couple of comments about that. Most of the proposals around the licensing and qualification area are aimed at increasing the professionalism of the industry and also to address specific issues in relation to consumer protection. So that's good. With the current industry focus on experience and a good experience with clients, that's a really good thing. Now, I was previously concerned about the abolition of the business agent's license category. However, since the initial release of the reforms, it's been clarified that this will be selling businesses will be a part of the real estate agent's license, meaning that if a person wishes to sell a business, or a going concern as it's referred to, they'll need to hold a real estate license. Also, there'll be a transition process where those people who currently hold a business agent's license will be granted a restricted real estate license under the new reforms, restricting them obviously solely to the sale of businesses. So it's not that any person out there will be able to sell a business. It will be there for real estate agents to do it and then incorporate that. I was also previously concerned about the deletion of the corporation license category. However, this has now been amended, at least in the short term, and the corporation license will remain as a requirement for those people operating their businesses as proprietary limited companies. Fair Trading have stated, however, that they will be addressing this as a future issue to reduce some red tape. So Fair Trading is stating that there'll be a transition period with the licensing process, where the most likely transition process will be that people who hold a license at the time of the new reforms being implemented, and they're predicting about the middle of next year, so middle of 2018, and upon application to New South Fair Trading, they'll automatically be granted the new licensee in charge license category at that time, or at any time in the future when they make that application, at least for a 2-year period. So this means that you ever intend to work, commission only or open your own agency, that you will require that licensee in charge category for that purpose. So if you don't hold a license prior to the new laws, you will have greater training requirements and you will need to provide evidence of your past 2 years of experience in the industry and being assessed against specific business level competencies. So really interesting there is that we need to think about that new license category of licensee in charge. And what Fair Trading is saying is, and obviously this will come into the regulations, is that there can be more one licensee in charge license holder within a business. Now, whilst one will be the nominated person in charge of that business, other people can hold that license, so they can automatically take over when the nominated licensee in charge is on holidays, or they need someone for another branch, or however they're running their business. So there's going to be a lot more flexibility in this. So it's a good thing. That's enough about the licensing and qualification section. Let's move on to continuing professional development. Now, CPD for certificate holders will be gained through their completion of units towards their certificate for license qualification. So there'll no set CPD for them, but it will certainly be they need to be working towards their certificate 4 level license qualification. Now for licensees in charge will be responsible for ensuring that those certificate holders complete their training, which will be regarded as their CPD. Now, CPD for licence holders will change from 12 points to 6 hours. So this will have 3 hours of mandatory topics, and it's mandatory from the point of view of not that they have to do it, because yeah, you do, but it's mandatory because the topics will be nominated and detailed by Fair Trading, and that will be determined based on what the Reform Committee and or the industry consultation group nominate. So that'll be the 3 hours compulsory, and those 3 hours will be delivered by industry groups such as EAC or government agencies such as Fair Trading. Now, industry groups will be defined to include current industry groups and other entities that have been approved by the Minister to provide this compulsory or mandatory CPD topics. So CPD for licensee and charge licence holders will be the same 6 hours as the licence holders, plus an additional 3 hours focused on business skills. So there's the 3 hours mandatory that's set by Fair Trading, the 3 hours elective that you can participate in really anything related to your workday needs, and that could be from sales through to property management skills through to business skills. And then there's for licensee in charge, there's that additional 3 hours. And it's looking as if registered training organisations like ourselves will be putting that information through to Fair Trading when you have completed it. So the reforms around CPD are fairly straightforward and should be and will be much more detailed in the regulations when we get those. And CPD will continue to be a valuable annual program that's focused on increasing the skills and professionalism of the industry as a whole, which will, as an end result, will be really good for consumers. Okay, that's the licensing, CPD, the training bit out of the way. Let's look at the third issue, which was conduct and accountability. Now, licence holders will be required to provide an annual update to clients regarding their fees, charges and commissions. This is a consumer protection mechanism allowing the consumer to opt out of an agreement if they believe that they're being overcharged for the service that they're receiving. So it's an opportunity for you as agents to give good information about the service that you're offering. Agents will not be permitted to receive gifts or other benefits over the prescribed amount, which will be nominated in the regulations, looking like it'll be $100 at this stage. Agents will not be able to, it's because it may be considered as a conflict of interest. So this, however, does not include a gift received in gratitude for services provided under an agency agreement. So if you've got a client that you've just provided a service for and they give you a thank you gift, that's okay. That's not what this is about. Next point is that the reforms will require licence holders to obtain 3 quotes for services when the cost of the goods or services is more than $2,000. Now, that's for property management services, strata services. So this is already undertaken as best practice by most agents, so it's simply legislating for good practice, and it's also in the strata legislation. What's a really good thing is that there will be a more definitive explanation of what is material fact and what is not for the sales process. Now, this is really long overdue, as the definition contained in the Residential Tenancies Act is specific and easy to implement. So this will make it much clearer for sales agents, vendors and purchasers to understand the type of information that needs to be disclosed in the sales process, and a lot more about your responsibility as an agent in ensuring that that information is accurate and that you have it in a timely manner. Okay, the fourth issue under the reforms is audit processes. So there's a couple of points here. Agents will be required to transfer rental income, except for authorised expenses, to landlords at the end of each month, unless specifically instructed not to do so by their client. Look, the aim here is quite, it's a little bit difficult to understand. I'm even finding it difficult to say it. Because what they're looking for is a nil balance in your trust account at the end of every month. Yeah, we all know that's not possible, but it's about getting it as close to that as feasible. So we've got a fair bit more work to do on discussing that through with Fair Trading, so leave that with us. We're as bemused and confused about that issue as is everybody else. So we're certainly talking that one through. Another point is, and this one is really straightforward, agents will hold separate trust accounts for rents and for sales. Look, many agents already do this, but it's a matter of that it will now be a requirement that you must. Third point is that all audits of trust accounts, whether they're qualified or not, will need to be lodged with New South Wales Fair Trading. So it's back to where we were a few years ago. This is a good consumer protection action and a good decision from Fair Trading. So Fair Trading will also develop an online portal for the lodgement of the audits, so it'll make it a more streamlined process, and you'll know when your audit has been lodged by your auditor. Okay, the final area, let's have a chat about disciplinary powers. Fair Trading will give themselves, through these reforms, the power to temporarily suspend a licence or a certificate of registration whilst an investigation is underway. They will also introduce a power to immediately cancel a licence or a certificate of registration that was obtained using false particulars or issued in error. They will also introduce a power to suspend a licence for failures to submit an audit. Okay, so we've got a couple of concerns about these reforms, as all people should obviously be considered innocent until proven guilty, not the other way around. And mind you, agents who are doing the wrong thing should be prosecuted accordingly, but not have their businesses undermined by a possible vexatious complaint from either a client or a competitor. So really there's a lot of issues there to consider. And you know, if you're ever under investigation, obviously the first thing you do is seek legal advice. And for those of you who are EAC members, obviously that comes as part of your membership. So that's a really good point to remember, that your membership will help you out in that way. So guys, I hope that this information has made it a little bit clearer. If you've got any questions, then send them in to us, because we can always address those through our weekly Facebook live sessions, or we can make it a newsletter if it's something that is of a detailed impact. So have a great day, and we'll see you in training.